Hello and welcome to this short update video in relation to the furlough scheme. So back in November, the Chancellor announced that the coronavirus job retention scheme was to be extended up until the 31st of March 2021. However, in recent news just published today, will be subject to a further extension up until the end of April next year. And this is to provide support to businesses and employers as we navigate through the tiered restrictions which are currently affecting the country. And it also reflects evidence that the economic effects of lockdown and the tightened restrictions are having much longer lasting impact on businesses than the actual duration of any restrictions. So, in relation to the furlough scheme, for any claims that are running from the 1st of November to January 2021, they will be subject to the original terms of the furlough scheme we saw back when it was introduced in March. So that will be with employees receiving 80% of their salary for the hours that they haven't worked, which is again capped up to a maximum of £2,500 per month. Hence, it's more generous than the scheme that we saw operating in September and October. Employers will still be obliged to pay employer national insurance contributions as well as pension contributions, and they should continue to pay their employees in respect of any hours that they do work in the normal way. So that's particularly if they are operating a flexible furlough scheme. And like before, employers can still opt to top up employee wages if they choose at their own expense. Now, the scheme in its current format is designed to be reviewed in January 2021. And so as a result of this, the job retention bonus, which was due to be paid in February, the intention of that has now fallen away, so that will no longer be applicable. However, it's likely it might be reintroduced at some point down the line when it's appropriate to do so. And again, because the furlough scheme has been extended, the job support scheme, which was designed to come in and take over, has also been postponed. Now, the guidance that covers the coronavirus restrictions has been released back in November, and again it's already been subject to several amendments already, so we'd always encourage you to check the .gov website for the most up-to-date version. Now, moving on to the actual framework behind the coronavirus job retention scheme. So the HM Treasury did publish the Coronavirus Act 2020 and the functions of HMRC back on the 13th of November 2020. This was actually the fourth version issued by the Treasury, given the various amendments that have taken place already. Now, the fourth Treasury direction is what formally sets out in law the extension of the coronavirus job retention scheme, which obviously is now going to continue until the 30th of April 2021. It also sets out details of how the retention scheme will operate between the 1st of November and the 31st of January 2021. And it's likely that a fifth Treasury direction covering February to April will be published in due course, which, as we've said, might reflect some different contributions in respect of employers. It also formally withdraws the coronavirus job retention bonus, which we said is no longer applicable for the time being. Now, the rules cover a wide range of issues, including eligibility, furlough agreements, claim periods, reference salaries, calculating the usual working hours permitted, and reorganisations and the time limits for making a claim. So it very much contains all of the procedural items that you need to know when making claims under the job retention scheme. So moving on now to what the actual key points are in relation to the changes that have happened since the original scheme was introduced. So the first one being the actual publication of claims. So it is now a condition that making a claim, the employer will accept that HMRC will publish information about the claims on the internet that that employer has made. So this will include the name of the employer and a reasonable indication of the amount that they have claimed. Now, an exception can be made where an employer can show that the publication would expose their workforce to a serious risk of violence or intimidation, and further information about what that means in practice and how a request can claim information not to be published is expected later on in the guidance. The next change is in relation to furlough agreements. So it's been put in place that these must be put in place at the start of the relevant claim period, but can be varied during that claim period, for example, if there is any extensions on to the end of that. And it should be sufficient to update an earlier furlough agreement to cover this extended period, provided that it is done under the whilst the employee is furloughed still. Now, there was a small window of opportunity for employers to backdate agreements. However, this has since passed. The next key point is in relation to notice periods. So in that regard, any claims may not be made for any day in which an employee is currently serving their notice. So this includes people serving notice of retirement or resignation. And this is particularly the case for any claims between the 1st of December 2020 and the 31st of January 2021. And the latest guidance says that this includes both statutory and contractual notice periods. So any claims for under the furlough scheme from the 1st of December couldn't actually include any employees who were currently serving their notice period. And redundancies, again, must be made in accordance with any employment law. So whilst statutory redundancy and statutory notice pay must be calculated on the employee's usual wage and not their furlough wage. And we did a earlier video in relation to redundancy redundancy processes, which you can watch our previous recording for. The next key point in relation to the furlough scheme is the actual criteria. So there is no maximum number of employees that an employer can claim for, and an employer can claim even if or the relevant employees have not previously used the furlough scheme before. So this rule is slightly different because the original scheme meant that if you were placed on furlough at the very beginning, you could then become what's called a flexible in respect of the scheme, but there was a cut-off point by which if you hadn't already been placed on that scheme, then you wouldn't be able to in the future. However, this rule has since changed and you can be placed on furlough even if you haven't been previously. The next key point is in respect of eligibility. So employers can claim for employees who were employed on the 30th of October 2020, as long as they have made a PAYE RTI submission to HMRC between the 20th of March 2020 and the 30th of October 2020. So employees that were employed and on the payroll on 23rd of September 2020 and who were made redundant or stopped working for their employer after that date can be re-employed and claimed for. So that is the key date. The next key point is then in relation to flexible furlough. So this is not something essentially new and was introduced as part of the original furlough scheme. And this will essentially continue. So employers can furlough employees for any amount of time and any work pattern, while still be able to claim the grant for the hours that they haven't worked. So this allows employees to continue to do some work if there are hours available. The next point is then in regards to the reference salaries of employees. So employees who have been previously furloughed will continue to have their reference pay and hours based on the existing furlough calculations. Employees, however, who have not been previously furloughed will have a different pay and hours based on a different reference period. Broadly, the pay will be based on 80% of the wages payable in the last pay period ending on or before the 30th of October 2020 for those that are on fixed wages, or 80% of the average payable between the start of their employment and the 6th of April 2020, whichever is the later of the two, and the day before the retention extension furlough period began for those that are on for variable wages. The next key consideration is for those who are shielding. So employees can be furloughed if they are shielding in line with public health guidance, or they have a need to stay at home with someone who is shielding. But this doesn't, of course, mean that they have to be furloughed, and it's ultimately down to the discretion of their employer. The next point is in relation to those who are returning from maternity leave. So employees that are returning from maternity leave need to give the statutory 8 weeks notice to end their maternity leave early in order to be furloughed and get the furlough pay, which is typically higher than the statutory maternity pay. So the usual 8 weeks notice still applies. The next consideration is in relation to 2P. So this is the transfer of employment regulations. So the new guidance direction clarifies that 2P employees are eligible for furlough if they transferred from their old employer to their new employer on or after the 1st of September 2020. So where employed by either their old employer or new employer on the 30th of October 2020 and are on a PAYE real-time information which is submitted to HMRC by their old or new employer between the 20th of March 2020 and the 30th of October, they must notify a payment of earnings for that employee. And the final key point is in relation to actually keeping a record. So the new guidance emphasises the fact that employers must keep in writing the fact that employees have been furloughed and keep this record for at least 5 years, just in case they are audited by HMRC. So moving on, the next section I'm going to cover is in relation to what do you need to do if you are furloughing employees. So the very first consideration is to ensure that your paperwork is in order. HMRC are going to be cracking down on businesses that they think are not dealing with furlough properly, and they're also going to be publishing names of all employees who claimed furlough from the 1st of December, as I've previously mentioned. So there are two reasons for this. So the first is to name and shame employers who don't necessarily need to rely on the scheme. And as we'll have seen in the media, a lot of companies are now repaying furlough payments back to the government. And the second reason for that is to help identify furlough fraud. So if an employer claims furlough pay in respect of an employee who is still actually working, unbeknownst to them, and they see the employer's name in the list of claimants, then that employee may well contact HMRC on their confidential reporting line. So it's another safeguarding principle to try and curb employers who are fraudulently claiming for under the scheme. The next consideration then is to ensure that you have your employees' agreement to vary their hours. So this can be done verbally, but it should always be followed up in writing to confirm their agreement, as essentially this is a variation to their contract. So whilst an employee doesn't need to sign anything, it's always best, in case the employee later tries to argue that they didn't agree for their employer to vary their hours or for their pay to be reduced to 80% of their normal wages. So it's best practice to keep a written record of that so that you can avoid any disputes later on down the line. The third consideration is for you to actually discuss the changes that you want to make with your employees in regard to their hours and their pay when they're not working. So when making decisions about what changes to make and who to offer furlough to, you should ensure that you're abiding by equality and discrimination laws in the usual way. So you need to make sure that you're not discriminating against anyone in any way. For example, against women who are on maternity leave or pregnant, or having a decision that is based on someone's age, their religious beliefs, or if they are a part-time worker. So it's important to ensure that when deciding who will be furloughed, that you are taking into consideration those factors as well. The next consideration is actually when to claim. So there are several cut-off points in relation to the furlough scheme and when making claims. So currently, claims made for December must be submitted to HMRC by no later than the 14th of January 2021, and claims relating to each subsequent month should be submitted by the day 14 of the following month. And lastly, the very key consideration, as I said before, is about keeping a record. So to be eligible for payments, you have to confirm that to your employees in writing that they have been furloughed, and to make sure that the agreement is consistent with employment law. So it's very important that you have your furlough agreements in place and that there is a record on the personnel file of these. You will need to keep a written record of this agreement for at least 5 years, and also keep a record of how many employees are being furloughed and how many hours those employees work, and the number of hours which you are essentially claiming for. Now, as we said, then an employee doesn't need to necessarily respond in writing, but if they do sign the document and confirm that they are in agreement, then obviously it places you in a much better, stronger position. If you flexible furlough your employees, then this also needs to be agreed with the employees, or if there is any relevant trade union in place to reach an agreement. And again, keep a record of this in writing. So it's important to remember, again, that employees aren't allowed to provide any services or do any work during the time that you record them as being on furlough leave. And that really brings us to the end of our short update. And as I said, the rules are changing all the time, so it's best to refer to .gov website for any of the latest guidance. But if you do require any advice or assistance in relation to either the implications of the scheme, any advice on drafting furlough agreements, or the redundancy process, then please don't hesitate to contact us. Thank you for watching.